Welcome to Expert Views on ADR EVA, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, arbitration, collaborative law, restorative justice, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike, postdoctoral fellow at the University of Brighton, United Kingdom, and a fellow of the American Bar Association section of Dispute Resolution. I'm delighted to welcome Anthony C. Markus to the EVA Show. He is a partner at Anthony Markus Sheridan, LLP, and has over 28 years of experience as a family law and estate planning attorney. He has been a member of the New York Association of Collaborative Professionals for over 13 years, co-authored the NYACP Protocols of Practice, and presently serves as co-chair of the Training and Education Committee. Anthony has advised diverse clients ranging from those involved in straightforward legal and financial matters to the complex involving multi-million-dollar businesses, comprehensive pensions, corporate benefits packages, and unqualified plans. He wears many hats, so I've left the link to his profile below. Welcome to the show, Anthony. Let me stop sharing.
Thank you. Thank you, Chinman. Pleasure to be here. Nice to see you.
Thank you. So without further ado, let me go straight to the questions. So question one is, what is collaborative law and its impact so far in the U.S.?
Okay. Well, two components that I'd like to point out. I mean, collaborative law, I think to understand is, and kind of to back up a little bit, to give some information, is civil cases or non-criminal cases, particularly in the United States. There are various statistics that show that anywhere in the ballpark of 90 to 95% of all civil cases, which would include family matters, divorce, wills matters, all those settle without going to trial. And so the concept behind collaborative practice or collaborative law is that you're engaging counsel and perhaps a team of people, experts and professionals, to facilitate a settlement of the case using various techniques. And so collaborative practice in its very raw form or very fundamental form is basically hiring counsel, attorneys, and clients who will sign an agreement. We often call it a participation agreement that indicates that they will not go to court with those attorneys. And if they choose to go to court, they'll have to terminate, or if you will, fire those attorneys and choose to go into a litigation case. So it's truly settlement counsel. And, it is much more nuanced. There's a lot more involved in collaborative practice that I could go on a little bit, but that's somewhat of a good overview. As far as its impact in the U.S., it not only has an impact in the U.S., it also has an impact worldwide. It has, there are numerous practice groups. Probably one of the most, involved and has the greatest membership is the umbrella group of the IACP, the International Association of Collaborative Professionals, which has members worldwide and in the United States and Canada. There's estimated 20,000 trained collaborative lawyers, and there has been more than 50,000 cases in collaborative practice. I have also read some other experts in the area indicating that there's no recorded malpractice case involving collaborative practice. I don't know that 100%, but I've seen that in other experts state that. So, I think it would lend itself to the sense that it is a practice that tries to be very client-centered.
Oh, yeah. Well, thank you so very much for that. So is there any history behind collaborative law?
Yes. I mean, the fundamental history is there was an attorney. The collaborative law has taken off and become most utilized in the family law arena, divorce matters and things dealing with children and family matters. A gentleman, an attorney by the name of Stuart Webb, back in about 1990, was pretty much is known as the founder of this practice. He had written to a judge in representing a client in a family matter that he would like to just. He thought it would be best if he just utilizes the practice of being a negotiation counsel, as I just described. And the judge said yes. And since then, it's grown into, from that point forward, it's grown exponentially with counsel and other professionals, which I can go into if you wish, throughout the United States and Canada and in many, many countries in the world.
Oh, okay, thank you so very much. So let me quickly go to the cost and time frame. So is there any measurable difference between the cost and time frame for settling matters or disputes or conflicts under collaborative law when compared to litigation or even mediation?
Sure. Well, I mean, these questions are excellent, and the amount of statistics and empirical data on some of these things is limited, but there was a study conducted by the IACP, which I just referred to, the International Association of Collaborative Professionals. And in their study, they said that the collaborative divorce that they did their survey on took 17 weeks, and the average litigated divorce took 17 months. So, and I think that's probably not, that's fairly accurate, if not exactly in terms of the time frame. Clearly, in terms of that litigated divorces that are going through the court system, are family matters. Okay, and most of their studies have focused on the family matters because that's where there's been most of the cases. Although there are cases in other areas. I can tell you from my own, anecdotally, from my own experience. I know, having practiced collaborative and having practiced litigated matters, that there's just litigated matters involve a lot more time. I mean, to give an example, in collaborative practice, discovery of financial information and documentation is in the participation agreement is open, and you have to, transparent, and here are the documents that you want. In litigation, discovery is, maybe a 20 or 50 or 30 page demand of documentation, potential depositions. So, clearly, when people undertake that process, with the court system and the time frame it takes, and the time frame it takes to go through that, and many other types of litigation tactics, if you will, and or practices, it's definitely often is going to prolong the process compared to a collaborative matter. Okay,
so in summary, it's much cheaper, and not it doesn't take much of your time as litigation does.
Nearly not as much as your time. I mean, no, it doesn't take as much as your time. And it's client centered. I mean, the parties, there's a balance, Chinwe, because the balance in a people that are in the divorce arena, you're dealing with people that are, uncoupling and changing into two family households. So the process of doing that is sometimes paced based upon their desire of pace, because it is a major change in their life. And so, although speed and pace is I would say in collaborative is more focused on the clients and what they want.
Yeah. Okay.
As opposed to necessarily always being very expeditious, not, because sometimes the way their emotions are and the financial practicality of how to change things doesn't always lend itself to being fast or slow. It lends itself to what they're trying to accomplish.
Yeah. Oh, thank you so very much. So it's client centered. So that's sort of one of the similarities between mediation and collaborative law. So is there any differences or similarities between collaborative law and mediation?
Yeah, good question. I mean, mediation, in general, the mediation model in the family law arena is usually, it's not exclusively, but it's usually one individual, usually an attorney, but not always, and the two parties. And so in the family law arena, unlike other types of civil matters, employment, employer, or former employee, employee or employer, or commercial matters, in the family law arena, it is more clients are going to mediation without their attorneys or without an attorney. And so, I have to distinguish between those two types of models. If I focus for you on the family matter, the major distinction between that and collaborative is that you don't have the attorneys representing the parties in a face-to-face meeting. Collaborative usually involves, and today also via Zoom, or virtually, involve face-to-face meetings, if you will, in which you discuss different stages and issues involved in that case and negotiate those issues. With counsel in mediation, you do that usually with just one individual and the two clients. So let's say the spouse is involved in that particular matter. And I think the concept, just to get to the nub of the distinction, is some people prefer to have their counsel involved in the matter. And where mediation and collaborative practice are similar is that they have an interest-based negotiation model, meaning that they look at the interests of the parties, they set priorities of interests, and try to problem solve and negotiate based upon that terminology, as opposed to, or in contrast to, litigation or legal terms. So they are similar in that respect, but they're distinguishable in the sense that you have in collaborative, it might be a more better fit for someone that wants to be sitting in that room, virtual or in person, with their counsel present, to help facilitate conversation in an interest-based model, either by speaking for them on sometimes, or helping to encourage them to speak with the comfort of that counsel present with them. So the models are very different, and sometimes you have clients that come to me, and I will, try to, or I will engage in explaining to them the different processes to resolve their dispute, and for them to really consider which process was best fits your particular circumstances.
Okay. Tony, can you be more specific about the models used in collaborative law?
So I'm sorry, what's more specific, did you say?
So on the types of models used in collaborative law.
Oh, yes. Okay. So, as I explained it earlier, basically, just to give a sense of it, you enter into a participation agreement. And in the family law arena, you have it's really like a little 3 or 4 page contract that basically explains, that you're hiring. Usually you're definitely going to have an attorney on each side. You're going to keep virtually everything communicated confidential. And so those components of the model, having counsel, confidentiality, termination of counsel if one party or both wants to litigate, those staples remain the same. Where the models are different is we add other ancillary, or I wouldn't say ancillary, other professionals. And we have an FP, we call them, which is a financial professional. We have a family specialist, which is usually those individuals are trained in mental health and dealing with emotions and stress. So in the example of the financial professional, I've had cases in the divorce arena where we have complex, it could be complex or not, but I'm thinking of a case right now that I handled in which we had foreign tax issues. We had we had issues that concerned complicated, financial matters. And so this financial professional, unlike the counsel, is neutral. And they come in, and so often, people in going through a family matter or even other disputes are dubious or suspicious of the financial information being provided, and are concerned because they're not in a litigation arena that it may not be genuine or transparent. And when you bring in the financial professional, this person is charged with making sure that they've done their due diligence in verifying the information, and it's being delivered, instead of it being delivered by one party to the other, it's being delivered by a neutral who's vetted it and presented it in a manner that makes both parties less uncomfortable that it is genuine and transparent. So the financial professional in a collaborative case, usually could be a CPA or has other credentials, is trained in collaborative practice in being neutral, can deliver that information to facilitate, help facilitate resolution, and also take that job or limit the job of the attorney in having to do that investigative work, because you're only having one person do it instead of two, and it can actually lessen the cost instead of what might appear to be increasing the cost when you think you have another individual. So that's the financial professional. If you like, I can tell you more a little bit about the family specialist, if you'd like.
Oh, yeah, you can go ahead. Maybe a summary would be
okay.
fun.
Yeah. So the family specialist, and I think some of the best ways to explain this to you. I mean, as I said, is a person that's trained in mental health, and they're what they're not, and it's important to understand in this model that, they're not a therapist to meet with a client going through a divorce or other matter to engage in therapy. Mm-hmm. They are more trained in trying to help diffuse and manage the emotion that is involved in negotiating a settlement with someone that you're connected to, whether it be in a divorce matter, maybe even in a sibling, if it's an estate matter, if it's in a family business. That person is there to help diffuse the emotion, and they will meet with the parties either together or separately to try to help them with issues that are difficult. In the family, I've had people that I've dealt with that have had addiction problems. I've had people that are angry and frustrated that, about the circumstances they find themselves in, and having this person who's trained with understanding the emotions involved when you're in a very stressful circumstance helps to diffuse that emotion so that it doesn't get in the way of reaching practical, durable settlements.
Mm-hmm. Okay. So can the collaborative professional be evaluative or facilitative when it comes to settling disputes?
I'm sorry, I couldn't hear you. I apologize.
Can they be facilitative or evaluative?
They can be both, exactly.
Oh, okay.
Facilitative or evaluative. I mean, for example, in the financial professional, usually what they do is I've had many cases where the financial professional will get on the phone with both spouses who are ending their marriage, either simultaneously or separately, and they'll elicit information, and they will put that data into a format for them both to read. But by the same token, they could be sitting in a meeting and say, I have a tax question, or I have a finance question about real estate or getting a mortgage, or and ideas of, can we refinance this property? And then, so they can provide neutral information based upon their experience and knowledge.
Okay. So can they collaborative law professional practice in another state where he wasn't trained?
Yeah, well, I mean, I answer. So for one of the things that's understanding in collaborative practice is that particularly for, let's say, for an attorney, you're still a member of the bar of that state, and you still are serving as a lawyer for that state. And much law in the area of divorce or family law or estates is germane, is usually state law, not federal law, not law that is applicable to the entire, let's say, the entire United States. So lawyers that are trained in New York or New Jersey or Connecticut or California or Texas, et cetera, and admitted to the bar in those states, for the most part, would be precluded from engaging in a practice outside of their state unless they're admitted in more than one state and they have, and therefore hopefully have knowledge of that particular law. So even though collaborative doesn't, it's an interest-based negotiation. So the law is a guide, but it's not a mandate. And so I'm kind of a two-part answer to your question. One is, yes, I would say that I would not practice I'm admitted in New York and Connecticut, but I'm not admitted in New Jersey. So if a New Jersey case came by, I would not practice there because it wouldn't be appropriate. It wouldn't be ethical or appropriate. But by the same token, when you're in collaborative, you'll explain to the parties, well, here's the law. And quite frankly, we can't give you the definitive answer on the law because it varies sometimes from judge to judge and case to case. And, nobody can predict with 100% certainty or even close to that often what the outcome is going to be because a given judge on a given case, will vary in terms of the determination on various issues. But we will, and we're required to, and advise our clients, here's the law, this might be our prediction of an outcome within a range, and explain that to the clients. And if both counsel and the collaborative practice don't agree 100%, we'll even concede that. And we'll say, look, I have this view, my counterpart counsel has that view, be it as it may, let's not, I don't think that necessarily has to get in the way of our negotiations. And if it did, we could always go to a third party and use a model of, okay, we can get a neutral third party attorney and let him or her explain what they see as the law and they could answer that if you parties find that necessary. But we will be respectful. So if another attorney says to me, Tony, I have this view on division of this asset or on this support amount or on what would happen in a state matter. I would say, okay, I understand your view and I respect it. I have a different take on it and I would explain it in a respectful manner and we would present it to the clients in that fashion.
Okay, so apart from the family matters, what other cases or disputes can be settled under collaborative law?
Well, I think the collaborative model is an excellent model for many, many cases, quite frankly. I think where it has been most efficacious is in areas where you have individuals that have a close connection with each other. So, obviously one area that I have been discussing is in divorce or family law. Usually, clearly in virtually all divorce cases, in most divorce cases, not all, but most have children. And often you have people that care about each other. So obviously you may be ending your marriage, but you're not ending your connection. So entering into you go through the rest of your life, usually connected to your former spouse. And so in those areas, collaborative is helpful because you're not just dealing with financial issues, you're dealing with issues with children and communication between those parties. And it's a method that helps address how you will maintain that relationship. Similarly, in areas of inheritances in which children, it's often among siblings, brothers and sisters, when you see a lot of infighting sometimes when the mom or dad has passed away or it could be other models. And then there's the siblings, are having disagreements with each other. And they also have this family relationship that continues. Or in the family business in which one person or a couple of people are involved in a business and one may be leaving or they have a disagreement about how to manage that business and they want to go their separate ways. I think in those arenas, it had been very helpful. However, I will say to you that I have, and I don't know this as much personally, but in some of the trainings that I've done, in some of the lectures that I've done, we have seen collaborative utilized in areas of medical malpractice and, and in other areas. And it's interesting that, I think that's much more uncommon, but when it is utilized, what you find is that the person that that it claims that they were injured by let's say a physician, when they can have a dialogue between them, doesn't just fall to the money. It falls to this is what's happened to me, and when they can have a face-to-face conversation, whether there's an apology or an understanding or an empathy factor. It has been helpful in that arena, which is very different from the traditional civil model of basically duking it out among two individuals to see who can get the best outcome or the outcome that's most favorable to them in a financial respect.
Okay, so Tony, what is your advice for people pursuing a career in collaborative law and potential users of collaborative law?
Sure. Well, I mean, I think the first thing is you've heard me explain that there's a paradigm shift in managing cases or representing clients in cases involving in the collaborative practice. You have to have the temperament and desire, I think, initially to work in this arena in which your skills as, let's say, a cross-examiner is not necessarily going to be transferred into your skills as a collaborative attorney. So a litigator mindset of doing their job to protect their client by going into trial and being as aggressive and as thorough and as investigative as possible is not necessarily the same skill set that's necessary in a collaborative matter. So I think the first thing you evaluate is what your temperament and what your desire is and how you want to practice as an attorney, if we're talking about that. Practically, Chinwe, what I think one should do is there are practice groups all over the United States, Canada, and the country. And in New York, we have the NYACP, which is the New York Association of Collaborative Professionals. It has over 120 or 30 professionals that are members of that organization, of which I am also a member. And and then they're all over the country. Some of them are larger, some of them are smaller than that, but they're all over New York State, all over the United States and Canada. I would search out that group. Become a member, get trainings, go to your trainings, read, become educated, and that way you get cases and you become more expert in your craft.
Okay, thank you so very much. We're running out of time. So can you summarize the aims and objectives of Markus and Sheridan LLP?
Sure. I mean, we, myself and my partner, Mark Sheridan, pride ourselves on this methodology of dispute resolution, whether it be in the area of family law, estate matters, employment, employee matters, whether it be in collaborative mediation. We are, as professionals, as attorneys and counselors at law, truly believe that the best way for many disputes to be resolved is through either a collaborative or mediation process. And so not only is our business model, which is, for the firm's business model, but also because of our own professional and personal sensibilities, we tend to practice in that arena. And so we do a fair amount of collaborative work and mediation work. We do a fair amount of collaborative involvement in training. I'm a member of the training and education, or the co-chair of the training education committee for the New York Association of Collaborative Professionals. And that is a committee that facilitates many opportunities to learn and train in the area of collaborative practice. Mark my partner, Mark Sheridan, is very involved in mediation and doing a lot of mediations for the court system and privately in employment and other civil disputes. So Markus and Sheridan focuses a good part of its practice in those areas of dispute resolution.
All right, thank you so very much for your insights and perspectives on the above subject matter, that's collaborative law, and also for the teaching and learning you've shared with us today. I believe that potential users would embrace all you stated herein and opt for collaborative law whenever the need arises. And thank you so very much for offering a comprehensive or detailed overview of collaborative law.
Thank you, Chinwe. I appreciate the opportunity to be able to talk about it and to work with you on elucidating individuals and professionals on this topic.
All right. Thank you so very much, Mark. Take care. Bye.
Bye now.
Bye.